Right. So with that, we're going to go through it. Today's webinar is COVID-19 update, reopening Florida in your communities. We've taught this and really going through this, it seems like almost every day provides some type of a change. We've worked with some communities in Southeast Florida, for example, where there are certain executive orders in place that remain in place that the governor's order hasn't touched. And we won't go into as much detail as that because we know most of you are probably in Central and Northeast Florida right now, or most of the locales that really do not have the current as restrictive of orders maybe as in Northeast Florida. We're pretty much mostly open back up, or at least reopening from the standpoint of what might be in place for community associations. So we'll be sure to go through that. So what we're going to talk about are the current orders that are in place, reopening amenities in your community, which kind of ties in with what the current orders are. We'll talk about some contractual issues that we've seen, and then any long-term effects that we're seeing that we think that we'll see from this, whether it's from statutory changes, whether it's from anything to do with collection issues. So we'll kind of try to read the tea leaves, look into our crystal ball for you and see what we think might be coming down the pipeline there. Oh, the other thing I want to mention too, if you see it, we are recording this. That's for the purpose. So if you see that dot, it's because we're going to be recording it. We're going to be placing it on our YouTube channel. So if you see that, that's what's going on. All right, so for current orders, Jim, if you want to kind of talk about the phase 1 reopening, understanding that we might be getting a phase 2 anytime soon, but at least what's in place right now.
Right, and we've already had like a phase 1A reopening, if you will. And like Ed was saying, on a daily basis, some of this information may become stale because the governor might wake up one day and say, okay, well, time for phase 2, right? But what Executive Order 2112 did, the phase 1 reopening, I really pulled three matters or three subject matters that pertain to community associations. Of course, it did other things, but I think the three main points to talk about as it pertains to community associations are the amenities, vacation rentals, and the issue of preemption. And in terms of the amenities such as gyms, fitness centers, pools, things like that, the executive order does not require the amenities of residential buildings to be closed, but your local government orders must be analyzed. Again, up here in Northeast Florida, where our primary office is, we don't really have local governments doing a whole lot. But in other areas in South Florida, like Miami-Dade, Palm Beach, and other areas, there are local governments taking more action. But Executive Order 2112, it extended 2071, which also concerns amenities, but that order never applied to gyms, fitness centers, or pools, which are an amenity of a residential building. And again, we're talking statewide applicable orders, not local orders. So it's also important to understand that the issue of whether the association is legally obligated to close an amenity and whether it should close an amenity are separate questions. So moving on to the issue of vacation rentals. So Executive Order 2112 extended the prohibitions on vacation rentals as provided by Executive Order 2087. Presently, we don't have a sunset provision in the existing governor's order. So as of right now, it's indefinite, and we could only speculate as to when the governor might wake up one day and say, okay, vacation rentals are fine now, right? It's literally on a day-by-day basis, subject to the whims of the governor at this point. Executive Order 2087 prohibits parties engaged in the rental of vacation rental properties as defined by a statute from making new reservations, and there are exceptions. And it also provides that the prohibition shall include the rental of any house, condominium, cooperative, or dwelling that is also a transient public lodging establishment, as that term is defined by a statute. So here are a couple of exceptions, or more than a couple. Rentals to persons performing military, emergency, governmental, health, or infrastructure response, or travelers engaged in non-vacation commercial activities are not prohibited by the new executive order.
One thing I wanted to jump in, I know we might have some people from this community, but it was an interesting question of some vacation rentals, or they appear to be vacation rentals that might fall under this exception, where it was two individuals that were providing, and they had even a letter, they performed the services in North Carolina and then in Florida, and they had a letter from the Department of Agriculture in North Carolina stating that they're an essential business and what they provide, and they have an office in Florida as well. And so on its surface, it might seem like that's a proper exception. The problem was that when the community, there was notifications that there was a bunch of cars in the driveway, and we took a look at the guest list from the guard, and we found 14 or 16 people on the guest list, which had anywhere from newborns all the way up to they're all family members. Almost all of them had the same, family name there. So whether or not you can use this exception to otherwise, maybe even if you are providing that permissible service, the question then is whether or not you're allowed to bring all your family members with you and effectively use it as a vacation home or not. It's something that it isn't defined. I can see the support of stating, hey, this only applies, it's really meant to allow people that are here on a short-term basis that are providing a service, and I'm not sure why you need to have all your family come with you and stay here with you while you're providing that service. Another instance from, I believe, a similar community was people that said that they were providing this exception, but they were going to be working essentially remotely within their condominium unit they're going to be renting. And so even if they are providing this service, do they have to verify that they're going to be leaving and going back? Are they allowed to work remotely? It's an interesting question that we don't have answers for specifically. The other thing that has come up for a number of communities, and we've had this for a couple where even the owner that had received a letter from us stated, hey, my rental agency told me to sign this letter saying that I'm providing one of these services. And he just said, I just signed what they put in front of me. So you have this instance of maybe owners aren't even realizing what they are and aren't allowed to do, although there's an obligation on their part to understand what's going on. There's an executive order from the governor. To me, the rental agency should know better, especially from that standpoint. I understand that it affects their business line, and that I know that there are challenges to the executive order from some rental companies that are essentially stating, why are you focusing on vacation rentals and not allowing those, but allowing hotels to still operate? And so it's an interesting question, and we'll get into a little bit more maybe from an enforcement standpoint, but some things that have come up regarding the exception side.
Yeah, and like Ed said, there aren't many answers to those questions because you're talking about law, right? An executive order that's been in place for a couple of months. So it's not like courts have really decided and fleshed out what all these provisions actually mean. But there are, different sort of strategies that we're seeing to either get around or try to fit within some of these exceptions.
So I think I saw one question here real quick from Suzanne regarding hotels. This is regarding vacation rentals. It's not necessarily as to hotels, which is why there's a disagreement from the rental agency saying, why are you taking away our ability to earn a living and allowing vacation rentals and not allowing vacation rentals, but still allowing hotels to operate?
Yeah, so essentially one of the grounds on which you can challenge governmental action is if they're acting arbitrarily, especially as it pertains to a constitutionally protected right. So these kinds of situations are difficult, and admittedly the governor's in a difficult position. On one hand, he wants to protect society and the state, but on the other hand, he's supposed to be acting within constitutional boundaries, some of which are vaguely defined. So these types of situations stress the limits of our government and constitution, and certainly this raises constitutional concerns.
Yeah.
Which I'll talk about again in just a moment. Okay, so we talked about some exceptions, but that was before we actually talked about what was prohibited in the first instance. So how this law essentially defines vacation rentals, it cites to two statutes. One statute defining vacation rental, one statute defining transient public lodging establishment. I'm not going to read them to you, they're there in front of you, but to generally summarize, if a rental is to an exempt person, or if the rental is for fewer than 30 days or 1 month, but the unit is not rented for that short of a duration for more than 3 times in a calendar year, or if the rental is for a period of greater than 30 days or 1 calendar month, then the executive order doesn't prohibit that rental. However, it's also important to understand that that executive order is prohibitory in nature. So it doesn't permit a rental that is otherwise prohibited by your governing documents.
Yeah. All right.
So a couple of final points here. If the association doesn't have tenant or lease approval authority in its governing documents, the executive order doesn't grant any more authority than the association otherwise has. So the association shouldn't try to take on the role of enforcer in that context. What it should do is if the association believes that a law or the executive order is being violated, contact law enforcement or the Department of Health as applicable. If the association does have tenant or lease approval authority, or if there's a compliance with law provision in the governing documents that we could potentially tie into, the association has the option of either contacting law enforcement, which would be our first recommendation because, hey, frankly, it's free, right? You don't have to pay us for that. And the other option is potentially instituting covenant enforcement or rule enforcement proceedings. From a practical standpoint, we're not going to get in front of a judge to kick somebody out before their rental would otherwise terminate anyway. the COVID situation has affected the efficiency of the court system pretty significantly as well. So the courts are directing a lot of their attention to critical and essential services, or those that they deem critical and essential, which mainly is either family law or criminal law types of matters.
So I think maybe just taking a couple of questions here regarding, because I know there's some about vacation rentals and what if you see it, what should we do about it? Bob asked the question, how do you handle an owner renting their unit but saying there are friends or family? And so that comes down to not only in this context regarding the governor's order, but whenever we have, we're trying to enforce our rental restrictions. I've seen this in other communities, even outside of the pandemic, and becomes a difficult issue. It's a proof issue, essentially. And you have to get down, if you're not otherwise required to have a copy of the lease, it's hard to verify whether or not they're actually renting it versus whether it's friends and family. As Jim has stated, the best way to handle it in the moment, if you have a strong suspicion that they are in violation of the ban against short-term rentals, contact law enforcement. Have them say, look, we have somebody, they've got a bunch of cars here. These are new people that haven't lived in the community. And we have information, or we believe that they are in violation of the governor's order regarding short-term rentals. Let them handle that. As Jim stated, it's difficult for the association to do anything in the moment. What the best way that you could do it is to really hitch onto, there's a compliance with any type of local law or order or something like that that would be in your covenants. You know, if there's a lawful use, maybe you could tie it to that. You're talking about fairly broad language, though, regarding what's lawful and what's not. And the difficulty with this is we're going under the assumption, that's under the assumption that the executive order is constitutional and that the governor is able to do it. There are some arguments that have been made that it's not constitutional. We're not going to go through all that and have a 1-hour webinar on the constitutionality of it, although we could probably do that. But the main reason why I bring it up is that if that's what we're using as a basis for violation in terms of sending out a notice, imposing a fine, otherwise taking any other enforcement actions that you would otherwise take for another violation of your covenants, it's based upon a law that might be struck down or might not be lawful. And so that's the issue that we see with it of tying on to. I'm not saying that you can't, it's just that it comes down to, and if you've attended a webinar with us before, I like to use what I call is what's the risk tolerance of the board? Because that's where it comes down to, and knowing also that you're not going to be able to get an injunction in the moment. But if you do have it where you have fairly clear language, you can send out a violation notice. It may practically get them to stop doing it, or think twice, you know, and that maybe they get the person to move out. They don't bring anybody else in while the order is still in effect. But from an enforcement standpoint, moving forward, you're basically using a provision in your covenants that's piggybacking off of a newer executive order that could be subject to challenge. That's the biggest issue.
Right. So a few issues you have to look at. A, what authority do you have in your governing documents to deal with rentals in the first place? Some have provisions in their documents, some don't. Wow, I see a comment to speak louder. That's probably the first time I've ever heard that. Usually I'm yelling at people, not at them, but with them, I like to say. Message heard loud and clear. So do you have authority in your governing documents, or are you trying to rely on the executive order? And how much information do you have about whether there's consideration being paid for allowing someone to stay in the unit? So there are some proof and evidentiary issues that are difficult too. A lot of your remedies are going to be limited to punishing after the fact, not preventing on the front end.
So I think Michael's question is, what is the HOA's responsibility regarding this? If you become aware of it, what's our responsibility? I don't know that there is a legal responsibility. There's nothing in your covenants that says that whenever the association witnesses something that it thinks might be a violation of a federal or state law or something like that, that we have an obligation to report it. There's no real obligation from that standpoint. Do I think you have the ability to do it? Yes, absolutely. And it's just like, even we're outside of this, if somebody was trespassing in your community, or if you strongly believe that somebody's trespassing, we would tell you right away, contact law enforcement. Let them look into it and handle it. That's what your taxes are for. It's immediate response. It's not something that you have to do. But if you're worried about liability from homeowners saying, well, what are you as an association doing to enforce the governor's order? It's very difficult, especially when the association doesn't otherwise have lease approval powers, or if the only thing is that we're required to be notified whenever a property is being leased. So if you're worried about it from a liability standpoint, that you think that you need to stay on top of this and go door to door and check, or that you have an additional obligation right now in the pandemic that you otherwise would have had, I don't know that that's the case to really be from an enforcement standpoint. I think it's really, if you become aware of it and you have reason to believe it, I think it's perfectly fine for you to contact law enforcement. That's probably what we'd recommend doing. But should you be contracting for extra services to look out for this, I don't know that I would go that far. What do you think, Jim?
No, I don't think so either. Your responsibilities are in part dictated by the contents of your governing documents and how they're worded. So what obligations does it impose on you? Many, I don't think we're going to impose an obligation on you to try to enforce law. And I would, to the extent that anyone approaches you in your community under the assumption that you have a responsibility, I would be trying to disclaim any kind of responsibility. Just say, hey, look, if you believe someone's violating the law, go call law enforcement.
Yep, and that's, Kathy, you just asked that question. Can we tell owners to call law enforcement? Absolutely.
You can and should.
Yep. And then Susie had a question, I think that's kind of tied with this, maybe regarding whether it's a vacation rental or somebody coming in, if there's like a self-quarantine going on. The question is, can condo association communicate to other owners when an owner comes into the building that is doing a 14-day self-quarantine or has invited family to come and self-quarantine with them? The biggest concern that we have is I would want to be very clear that somebody does actually have it. And before I ever use a name, of course, I would want to make sure that that owner has consented to using their name as part of any communication. And the only example that we've given before is you might have somebody that says, hey, I just found out that I had it and I've been trying to be safe, but I have said hi to a couple of my neighbors out there and I've maybe gone and taken a walk from time to time and touched the gate or something like that. And so I'm fine with you letting people know so that if they feel like they've come in close contact with me, that they can, take appropriate action. I think only with that type of consent would I send out anything with that person's name. If you send out a general communication regarding if that person hasn't consented, but you know it to be a fact, that becomes a little bit hazier. I think it would be okay to send something like that, but I'd be careful about the message that you're trying to send with that notification that, again, the biggest thing, and we've kind of touched on it, the biggest thing that we're trying to advise against is making any type of statement or providing some type of communication that makes it seem like the association has undertaken a duty to prevent the spread of the disease and to otherwise, wipe down everything and prevent the spread to other owners. It's not practical, I think, for the association to be able to do that. And so whether or not that's the intent of the board, by communicating anything, I just would want to be careful. Even in that instance, I would say we have firsthand knowledge that there is somebody that is self-quarantining and that has come down with COVID-19. Owners are strongly urged, and owners and residents and guests or so on are strongly urged to follow all CDC guidelines. And if you're out in the common elements, that you do so at your own risk, and we ask that you please stay safe. Something along those lines, where it's more of an information passing than it is, here's what we're doing to help prevent the spread. This is what we're going to do in response to it. And then what if somebody contracts it? They can argue that the association failed in its duty, that it didn't even know it was taking on in the first place. Yeah. All right, so I think we're going to go on just to the next couple, and then we've got some more good questions, but we'll try to tackle those a little bit later.
Mm-hmm. Okay, the last issue is the issue of preemption. So preemption basically means that does the governor's order preempt or supersede local law, from your commissioners or local mayors? So unlike the Executive Order 2091 as clarified by 2092, nothing in 2112 expresses an intent to preempt or supersede local law. So what that means is that presumably local governing authorities can, impose their own mandates, if you will. So subject to constitutional arguments, you should look at those and be cognizant of them and try to comply with them. If you have questions, obviously you can coordinate with with an attorney. But again, up here in Northeast Florida, we're not really seeing as much that derogates from. Many are just following what the governor is doing up in this area. Most of Executive Order 2112 does not apply to Miami-Dade, Broward, and Palm Beach counties. However, a recent order, which I'll talk about in a minute, you can sort of strike through Palm Beach County there because that's no longer in effect. The frequently asked questions attached to the 2112 order state that local authorities are allowed to adopt requirements directly on businesses, operations, or venues, including buildings, beaches, and parks that are stricter than the governor's orders. So he's deferring to local governing authorities in that respect. So the bottom line, you have to understand and review local law, including local executive orders that are issued by local governing authorities, and determine whether and how you must comply with them. Some new ones, Executive Order 2114 and 2120. So 2114 essentially just extended the state of emergency in Florida for 60 days. Generally, the governor has to keep extending it every 60 days. It expires by law in 60 days. So we're still under the emergency declaration. 2120, which was on May 11th, lifted restrictions of Executive Order 2112 on Palm Beach County, allowing it to proceed with the phase 1 reopening. And it also added barbershops, cosmetology salons, and cosmetology specialty salons that adopt appropriate social distancing and precautionary measures to the list of businesses that can now operate.
Okay. The thing too, why the extending the state of emergency matters, and we've talked about this in previous webinars if you've worked with us and if we've provided you with an opinion, is that there are the emergency powers under the Condominium Cooperative and the Homeowners Association Act, which in order to use those emergency powers, there has to be a state of emergency declared. So there was some question and the governor went right up to the gun, essentially. I think he extended it on May 8th and it was expiring as of May 8th if he wouldn't have otherwise extended those. So that was some question there. So that's where it's important. You might say, well, what does it matter if there's a state of emergency? It's important for a whole host of reasons in terms of local municipalities seeking aid and so on, but also for our purposes for condo and HOAs and co-ops, it's for the ability to use the emergency powers and the various statutes. All right, so going into reopening amenities in the community, I know that probably most of you, this is what your question is, can we reopen and should we reopen? And the answer is it depends on the local order still in place. For the purpose of up here, for most of you that are in Northeast Florida, for example, we don't really have, and we haven't had local orders that have affected the ability for community associations to remain open. Now, we've had some communities that have said, well, we've closed down our gyms and so on because that's essentially, or they've kind of followed what maybe what the local orders were that didn't apply to community associations, but they kind of followed that as a basis for, well, we're going to do the same with ours, even if we're not required to. And I certainly think that's understandable, and I think that's a good basis for doing it. You know, there are much worse ways, I would say, and I think that would be a good way of doing it. But there's been nothing in place. I know I had one question regarding maybe some communities that were under the assumption like we had to close our pool because City of Jacksonville, that was what was required. Well, no, and I know that the mayor had come out and said, this never has applied to HOAs. I believe that was stated at some point. And whether or not there was a local order, there was still discretion, of course, and there still remains discretion on the board's behalf because it's the board that's responsible for administering the common areas and the common elements, the amenities, and making a determination as to what's going to be open or not. So if you close down and you have some residents saying, well, hey, it looks like this never applied to HOAs in the first place, the response would be, maybe not, but we still have the ability to decide as a board because it's our job still to take control of the common areas regarding the administration. Not that it's our job to prevent the spread of the disease. We're not trying to say that, but it's our job to affect, just like you place pool rules, it's the board's job to place a rule that says that the pool is open from 8 a.m. until 8 p.m. or something like that. It's a similar type of thing where it's your job to administer it. So don't worry about that if you receive any type of flack from it, I would say. Ultimately, whether amenities should be reopened is a board decision. If emergency powers are exercisable, and I put debatable in there because the statute, this is where we'll talk about it later, what we see, what we could see changing in the future. The statute technically applies to anything regarding property damage, which there has been no property damage as a result of the pandemic. The interesting thing is, in the statute it says that the board is able to determine that property is off limits to use, but that's under the assumption that it's been damaged from the storm and it's not safe to go there. In this instance, your pool may be perfectly fine and it's probably like a mirage in the desert almost, right? Where you have people that want to go use it, it's starting to get warmer out, and there's nothing wrong with it except for the fact that if everybody goes in at one time, there's the feeling that it's not safe because of, obviously, with the spread of the virus and the social distancing requirements. So the statute doesn't specifically say, the DVPR has come out and said, we interpret the emergency powers to apply in the instance of a pandemic. But they also said that we're suspending that it's only applied to property damage. What that basically is saying is that we need to change the statute because it doesn't technically affect us, but we're going to treat it as it does. And so under that assumption, if that's what the board is using, and I think that's one of the things, I think there's also an argument that even without the emergency powers, that the board may have the ability to consider them off limits to use under the general maintenance and oversight. There's some debate on that because owners have they have easement rights to use those properties, and obviously it's one of the main things that people rely upon when they come and buy into a community or if they're renting into a community is what type of amenities do we have and what am I paying my assessments for? So, but I've been of the opinion that I think that it's probably going to be okay to use the emergency powers as a basis, understanding that there is some subject to challenge if an owner were to ever challenge it. the board has broad powers over the administration of the common elements, just like we talked about, and really the business judgment rule. As long as the board, I think, is making decisions that are rational and that are based upon advice of whether it's local or state or federal health officials as part of its decision-making process, there's a long line of cases that says that the courts will not come in and try to second guess the decision-making of the association. Where I think you run up against, and Jim, maybe if you want to talk about a little bit, is just, again, the easement rights that owners have to be able to use these areas.
Right. So imagine, any managers that are with us right now, half the communications are, hey, why aren't they open? And the other half are, we need to keep these things closed. You're never going to make everyone happy in your community. Heck, if you can make anyone happy, I suppose it's a win. But what's at conflict are the board's powers to regulate the common elements and manage them in common areas and manage risk generally for the association versus whatever rights the owners have or the members have to use those areas in the first instance, which in many instances are characterized as easements, which are property rights, right? So it's those two competing interests. Ultimately, what we think is whether we can rely on the emergency powers or not, if you're continuing to keep them closed through this period, we think it's defensible. If you want to open them through this period, we think that's also defensible. But of course, there are some risks associated with each approach.
And Jim, I think if we could hear everybody right now, I think we'd hear a collective groan saying, what attorney speak that is, right?
Yeah, right.
And we apologize for that, everyone, but you have to understand, I think from our perspective, that there is no bright line test on this stating, and there's some question over whether or not we have a duty to prevent and provide for the health, safety, and welfare and to close the amenities down. There could be a case that comes out of this. There could be a wrongful death suit that's brought out of this that's bringing the association in, that the association was negligent, and we won't know until years from now, potentially, of whether or not the association actually has a duty to prevent the spread of this disease. And the best thing that we can say is we think that there are defensible bases. I think, and one of the questions that we had that somebody emailed me was, what if we live in a 55 and older community? I think that the facts matter for your community, and I think for 55 and older, I think there's even a stronger basis to decide to keep your amenities closed because of the at-risk population for using those, and if they're not used safely, then somebody being able to contract it, and then that could be the basis of liability. There's going to be a potential for challenge one way or the other. It comes down to the risk tolerance of the board. I do think that, from a contractual standpoint, and if somebody were to say, hey, I tried renting my unit, let's say it's not a short-term rental, let's say it's a 3-month rental, and they lose the rental because the amenities are closed, you've got an owner that sues the association for lost rent. Okay, you might have a contractual claim for a limited amount of damages there because you decided to keep it closed. The worst case scenario for opening them is somebody contracts the disease and they're somehow able to get a jury to agree that it was the association's fault and that the association should have kept the amenities closed, and that was the basis for some type of a bodily injury or wrongful death suit. That's the risk that we're having here. I think that what we're seeing, and I know I had a question from one of our associations we work with down in Ormond, that she makes a good point, which is that there is some basis that this doesn't spread through pools, that it basically effectively chlorine kills it. And I don't know that it's the water that we're concerned about. I think it's the use of the other areas for going in through the gate, using the pool chairs. So I think one of the questions was, well, what if we open it, but we remove the chairs to discourage people from hanging out there too long or just minimizing the number of surfaces that can be touched? And I certainly think that would be within the association's authority to remove the chairs or to stack them up. It's interesting, actually, in one of the counties, I think it was Palm Beach and Broward, that you were allowed to reopen, but you had to have somebody staff there making sure that it wasn't over capacity. And I think in one of those, you either had to remove the chairs or you had to have them stacked or removed in such a way that they weren't easily shifted around. I think we saw that for one of the counties.
Yeah. Very interesting. It's a good point to talk about. There is some precedent for someone suing the operator of a pool alleging to have contracted a virus in that pool. One case, it's a Florida case, I believe it's the 4th District Court of Appeal, and the 4th District Court of Appeal said that case needs to go to the jury. The jury's going to decide, causation is very tough to prove. How are they going to prove that they, contracted the virus on your premises as opposed to anywhere else in the world they may have traveled? Sure, it's a difficult question, but ultimately that's a jury question. Causation is a jury question. And when you say that, that means your case is expensive, win or lose, right? So the risks are significant. Whether there's a duty imposed by law that you can't get out of to keep your premises safe or free from viruses, it's still somewhat, to me, an open question. It's possible that a court may find you to have that duty, that you can't disclaim it, but going back to the level of communication with your residents, still try not to say anything, that someone can argue you've undertaken a duty. We want to still be able to preserve the argument that you don't have one in the first place.
Yeah. So that goes to the next point, which is notice to owners. Any communication provided to owners should be carefully worded. We generally would recommend include some kind of disclaimer language regarding the use of the common areas and common elements. It depends on what you're trying to accomplish, but it would generally be something like, please understand that you're using the common areas and the amenities at your own risk, and that the association has not undertaken the obligation to basically prevent the spread of any type of disease. It gets the owners to think twice and understand, just like when you go, if you're at risk whenever you go somewhere, right? You go to the gas station, you handle the gas pump, you go to the grocery store, you go anywhere else that's been open, there's an assumption, understanding that there's a risk associated with it. And I think that it's just a good thing to have in writing to your owners, if you do decide, whatever you do keep open, or reopen, I should say, that you provide that disclaimer language. Will that negate any duty that a jury may find that the association had? I don't know that that's the case, but I think it still helps from a negotiation standpoint for potential, whatever the total damages amount are, because the association is making it very clear that you're not out there wiping down every surface, and so on. The biggest concern, again, is setting the expectation or belief that the association is undertaking a duty to prevent the spread of the disease. So this is where, if you are going to be reopening certain amenities, we'd recommend providing this type of notification, and then also providing signage at whatever amenities that are open there. All right, taking a look at vendor access. I say vendor, but it could be any, you want to replace the word vendor with outsider access. I think that would apply here. There's a potential liability. One is just that owners are, again, it's a provision in the covenants, almost always it says that the residents are able to use the property along with any guests that they have. So that is a right that's provided for in the covenants that are recorded in the public records of whatever county that you're in. So you have an issue if you prevent guests. You have an issue from a potential monetary damage standpoint if somebody has contracted with a vendor or some type of service provider or something along those lines where you're not allowing somebody in, and that owner could potentially have a claim against the association because the association caused them to breach their contract or whatever agreement that they had in place, which resulted in damages to the owner. So there's some potential there. The main thing that I'm concerned with, I think there's ways to argue around some of that depending, and again, I would consult with legal counsel before you do this. But really one of the things is any type of like a medical service provider or any other type of outsider that might be, if it's an in-house care, type of worker, or if they're delivering medical supplies, could you imagine the potential for liability if you stop somebody from coming in and somebody was prevented from getting some type of from medical service or medical device or something like that? That's what I would be concerned with. I think there's ways to notify people that, hey, we are not preventing access, but anybody that comes in, again, does so at their own risk from the standpoint of, touching a keypad, and we would request that you ask any outsider, guest, vendor, whatever the case may be, that they wear a mask if possible, wear gloves, and practice social distancing. Again, communication to the owners as to what's expected, but whether or not you can close down the facility, I think there's a potential for liability there. But again, it depends on the nature of your community. I mentioned a 55 and older community before. There may be more of a basis to maybe have a little bit more of a strict process in place, maybe with an advance notice before the board allows somebody in, something like that. It hasn't been tested, but I think the facts do matter for your community. I think it's harder to keep guests and vendors or outsiders out from a large single family HOA where there's not really people in close contact, as opposed to a limited access condominium development where you only have a couple places to come in and the elevators are being used. There's no one size that fits all for this, but I think it depends on the type of community that you have. And I would, again, talk to your manager and talk to your attorney if you're considering doing that. Right now, though, probably you're thinking, okay, well, maybe I did that before, but I'm looking at easing it. So obviously nothing you can do to change that, but it is something to consider. So again, I put reconsider the reason for prohibiting, consider allowing, but placing disclaimer language at the ingress and egress points. All right, so let's just take a look, see if we had a couple questions here. I'm sure we did, regarding the amenities and outside access. There was a question right as we started, what about reopening the gym? That kind of goes along with the common areas. I think that just like anything else, I think I've seen most communities that have reopened their pools because they're open air places that you can safely congregate and without being too close to anybody. Tennis courts, you might have singles. I saw one community, I think I read something that said you're allowed to have singles play but not doubles play, for example. I mean, good luck trying to enforce that. I mean, I don't know. I could see it though, I guess, because you don't have, it's less likelihood of people coming into contact. Basketball courts, open air areas, but when you go into the clubhouse, the gyms, if the association were to decide to treat those a little bit differently, I certainly think that there's a basis for doing that, because you have equipment that people are necessarily by their nature needing to hold on to and use, whether it's pulling down the bar or using free weights or whatever it is, or touching the treadmill. It's an easier way to contract it. It's in a closed space if you have more people in there. So if you were to decide to keep it closed or to otherwise reopen it with limitations, I've seen some, if you have the way to do it, maybe one thing that I've kind of kicked around is, what if you have a reservation schedule, which basically says that we're asking you to contact and basically we'll have a sign-up list for when people can use it, or if it's you have a couple spots open at one time. Obviously, to enforce that can be difficult. We're not saying that you should have some type of gym attendant there, but at least it may be a basis. It's better than all the people flooding at one time if they understand probably 80 or 90% of the people are probably going to follow the rules if you ask them to. And so that might be a way of doing it as well. Rob had asked, can you provide any specific rules for opening pools and fitness centers? Is there limitations on the number of people in the pool or fitness center? There's nothing specifically for any type of local law, but I've seen some communities that have said we're going to reopen, but we're keeping it at X capacity. They're basically taking, whether it's 25% or 50% and stating, and again, whether or not you can actually enforce it and you're going to be able to enforce that, but just putting it as a rule, I think may keep people, hopefully most people employ common sense, but that may be a way. What do you think, Jim, from anything else?
Yeah. So a lot of these, it goes back to your level of risk tolerance, right? We're not going to say, hey, if you want to open your pools or you want to open your gyms, you got to impose these rules and this is what you have to do. It's really your decision. As the board members, you're in the driver's seat, we're in the passenger seat. We can explain some of the risks associated with both approaches, but it's ultimately going to be your decision. So, different clients are making different decisions. Some are saying, we don't want the risk, Jim. We're closing the gyms, and we're closing maybe the pool for a little while as well. Others are the complete opposite end of the spectrum. They're not, they're kind of going back to business as usual. And we have varying communities in between. Some have hired additional cleaning services and increasing the scope the scope and frequency of cleaning. So again, it all goes back to what we said earlier. Is there a potential basis for liability if someone were to contract a virus on your community or alleged to have? Yes. Okay. So it's likely that if someone wants to sue you, they're going to sue you anyway. But can you take mitigating measures or consider them? You can. So there are things you can do to try to devalue those claims as well. So it's going to come up to your level of risk tolerance. And also other facts are, what is the nature of the population of your community? How many people are using the facilities? So there are lots of factors to consider whether you're going to open them up. We're not going to mandate or dictate to you what you should or shouldn't do. The should question is really a question for you.
Chris makes a good point, and this is the community in Flagler County. When law enforcement was contacted, they told us they were not enforcing rental exceptions and to contact the DBPR. And so I would still encourage you to contact law enforcement. Sometimes it just depends on who you get when you call. But some may be more amenable to going out and at least having a talking to or getting more information than others might. But regarding contacting the DBPR, what that means is that there is a penalty for the rental agents that rent properties out on short-term rentals that are prohibited by the governor's order. You can actually, there are some penalties against them. You can report it, and it will affect their license. So that is another option to do as well. Susan asked about, with the gyms and fitness centers again, what do we need to do to ensure that it's safe? It's kind of what Jim has mentioned, which is Jim talking about gyms, right? I think it's perfectly fine and acceptable, maybe even recommended to increase your cleaning schedule. I just wouldn't advertise it a way of saying like, this is what we're doing to protect you as our members, because again, that makes it seem like you're undertaking that duty. That's the biggest thing, is kind of like if the whole point is to kind of make sure that you're preventing the spread of the disease, you can go ahead and do it whether or not you're actually advertising it. Right. It's kind of a talk about people who donate money. You can always donate money, but do you actually have to advertise that you donated it? Yeah. All right, so I think we're going to go through, I know we have some more good questions, so please keep them coming in. We'll make sure to address them at the end too. But going through contractual issues, vendor agreements. This came up with a community, and for some communities that we've worked with, take a look at your contractual terms regarding ongoing services. If you had some type of contract in place that's already started or was about to start, and whether or not if you're looking to try to delay any work, you want to take a look if there's anything in there about impossibility, or if there's anything that excuses performance because of, not many have the word pandemic in there, but you could use something. There's debate as to whether or not the pandemic is an act of God, for example. Or I've seen some provisions though that might be more applicable, which is because of governmental regulations. Now, whether or not that it excuses the association from making out a contract with a vendor, I don't know that that would be the case, but it is important to take a look at your contractual terms. Can the association dictate how work will be performed? We've had some communities ask this, whether or not you can limit crew members, requiring the use of masks. What I would advise our clients is that most businesses, especially if they're big enough businesses that have been around a while, and it's not just some small mom and pop shop that might be gone, tomorrow, they're going to want to make sure that they provide you with peace of mind, because they want you to, likely, you might need to use them again in the future. And I think that they're going to want to show that they're staying on top, and they care about the health, safety, and welfare of their own workers, that they'll agree and say, hey, this is what we have in place. This is our procedure for our company. And this is what we're requiring every day. We're doing temperature checks every day. We're making sure that they wear their masks and gloves, that they wash their hands when they're not using their gloves, X, Y, and Z. And if we have somebody that's been in contact, we're making sure that they're not out there with the crew. If you ask them to provide that, and even go so far as say, can you confirm that that will be the case for our community, and get them to put that in writing, most of them will. And at least that gives you something from a protection standpoint. But whether or not you can actually dictate limiting the number of crew members, it'd be pretty difficult to do that as an association. It comes down to more from a business standpoint. Does the company that you're working with want to make a decision that might make the project last a little longer for them, but ensures that the association stays happy so that they're recommended in the future?
Right. Can you legally obligate how they perform the work? Perhaps not. It's contract dependent. But practically, do you have leverage? Yeah, we think so.
Yeah. All right. So this kind of leads into the force majeure clause, and generally the performance or delay in performance of an obligation under a contract may be excused when it's impossible, impracticable, or financially infeasible. But really what you need is the force majeure clause, and I think there's going to be a lot of discussion about this. There's already been a lot of articles from the legal standpoint of the applicability of force majeure clause and whether or not they cover pandemics, but also when you're looking at a contract in the future, especially if you're looking to if you're having some type of big project, whether it's a roof replacement or something that is going to happen in the next year or so, unfortunately, it doesn't look like this virus is just going to go away at night. There's a lot of talk about whether or not there's going to be a bounce back in the fall. And so if you're entering into a contract right now for some type of service, take a look at the force majeure clause and make sure it talks about pandemics. Because what we have here is that there's case law that says that the force majeure clause has to be specifically included in your contract. It's not something that's implied. It has to be specifically included. And there's case law that says that the words matter. The specific wording is important as to the event. So if it just says something like, loss due to a hurricane or an earthquake, or I think there's something, a lot of times you see like civil war or civil unrest or something like that. None of those would really include a pandemic, of course. But when you have broader language, like due to governmental regulations or an act of God, and there's a question of whether or not it's an act of God, for example. But take a look at that as part of your negotiation, and I think that everybody's going to be in tune with this going forward. That would be the biggest thing. But remember, again, that usually the force majeure clause is used by the party that the association is contracting with, especially if you have a time limit on when they're supposed to perform. They typically use it to say, I can't get done on time, and here's why. I'm subjecting myself, here's the force majeure clause, and we're implying this from the standpoint of, it's going to take me another 30 days because we had a lockdown in effect that we couldn't do anything, something like that. Right. Hey, Jim, do you have any other thoughts on the force majeure?
Yeah, so typically a force majeure is not something that's going to excuse payment, right? If your obligation is just a payment obligation and you ran out of money, that's not a force majeure situation. Typically, it's going to be, like Ed said, someone who has a performance obligation to the association that will seek to rely on a clause like this to excuse itself for a delay in performance or an inability to perform.
All right, so going into kind of the last thing is the long-term effects, and then we've got a lot of good questions. I have some more that were emailed to me here. Some of the things that we're going to see: collections and financial issues. What's the impact of the unemployment numbers and the economy? What's that going to be on the ability to pay assessments? Obviously, we see that as something that you might not see it yet, but it's going to be happening soon, depending on when people are hired back and are able to go back to work, and how big of an impact it's had on their ability to earn income. I think you're going to see, whether or not it's to the same level as the housing crisis from 2008 through 2012 or whatever the exact time period was. I don't know that we're going to exactly see that, but I think you're going to see a big uptick in the people that are unable to pay assessments because of the loss of employment and because of anything else regarding the fallout from this from an economical standpoint. And so what we've been advising is it's more important now than ever, if you don't have it already, is to have a collection policy for the objective handling of delinquencies and having clear direction provided to management. The reason for it is just, it keeps you from a board of feeling like, well, what do we do with this guy? I think I heard that he's had some issues and he might get his job back, versus this one where you don't know the person and you might be treating them differently. I think, do you decide to maybe delay a little bit when you're going to be sending out a late notice and when you're going to charge the late fees and when you're going to send out an intent to lien letter? I think that's open for discussion, but what I wouldn't do is try to treat them on a case-by-case basis. It's important to have this, whether it's during the pandemic or really outside of it, but especially when you see there's probably going to be an uptick in the amount of collection activity, is to have that in place, because it makes it easier, makes it that it's more streamlined, and that everybody is handled uniformly in terms of anybody that's delinquent. And then you want to avoid any type of waiver of payment of assessments or late fees, especially on a proactive standpoint. There's statutory provisions that says that the association cannot waive the obligation for an owner to pay assessments. There are some very limited exceptions there, without going too far into the weeds on it. If somebody's going through foreclosure and they have a short sale on the table and they ask the association to accept a certain percentage, and if you don't, then you're going to get even less from the bank, that might be an instance to waive assessments from them. But for the most part, you're not able to waive the assessments. And even for late fees, what we would recommend doing is wait for owners to contact you, consider entering into payment plans. Maybe you suspend the late fees for a certain period of time, provided that the payment plan is met. But what you don't want to do is waive your ability to collect, because if somebody goes through foreclosure, if they sell the property, there's that obligation on the subsequent owner, depending on who takes title, to have to pay those amounts. So you don't want to waive them without having to, I guess, in the first place. And Jim, what other thoughts do you have on that?
Yeah, so the main point is, what we're trying to discourage is a prospective waiver of any type of monetary obligations to the association on a blanket basis. Like, hey, we're the board, we care about all of you, and so we're going to waive payment of assessments for the next 6 months. That's what we're suggesting that you not do. Instead of doing that, establish an objective and clear collection policy that's uniform. And if people contact you and want to establish payment plans on the back end, then there's some wiggle room to be compassionate and to work with people. What we don't want to happen is an association to have some kind of waiver or prospective blanket waiver that ultimately a financial institution foreclosing takes advantage of, because we want to be able to collect all we can from them.
Yeah. So take a look at that. Take a look at your collection policy, work with your manager, and work with your legal counsel to kind of help work together and figure out what the best thing is for your community. Electronic voting, what I see, I think coming out of this, I think we've even had questions about having meetings in the fall right now, and whether or not people are going to want to all attend an annual meeting. I've been to annual meetings where there's been 100 people or more. I don't know if people even in the fall are going to feel safe, really, maybe not even until we have a vaccine for this, of that many people all getting together at one time, where it's practically impossible to find a location where everybody could stand 6 feet apart. That's just going to be very difficult. And so what I think the association should do, that if you're facing an annual meeting that may be in the fall, or maybe you got through your annual meeting at the beginning of this year, is to take a look at electronic voting as a possibility. And really in line with that, take a look at your election provisions if you're an HOA, because by setting up electronic voting, especially if that's the only thing that is going to happen at your annual meeting, it might just have the effect of having less people that would even think about showing up in person because they've already voted online. So consider doing that. We've had some communities that are going through that, and have an election coming up a little bit less than a month from now, where the hope is, because so many people have signed up and with this all going on, that there's less of a likelihood that people are going to want to show up at a membership meeting. So take a look at that. It's not anything that you have to amend your bylaws for. It's something that there is a process you have to do in terms of a resolution that the board has to adopt, and that the members have to sign something opting into voting electronically. But it's not that difficult. You just need to have a little bit of lead time with it for the vendor that you're going to work with. So consider doing something like that. Some possible statutory changes, and this is where I'm going to talk about. I know we had some questions about virtual meetings for board meetings or membership meetings. So some possible statutory changes that we see potentially, maybe as to the emergency powers. I think that one is probably a given. I think that you'll see a change to the emergency powers that has an effective for maybe any state of emergency, and not necessarily as to property damage. Maybe they'll include pandemic. I don't know if they'll get that specific.
Right.
So I think just the applicability of it, and then within that, there might be the ability to have completely virtual board and membership meetings. Right now, the statute talks about the ability to have meetings with, it's really more as to the notice requirements than it is as to the physical meeting location requirements. And the reason is because if there's a hurricane, if you need to have a quick meeting, you need to make a decision quickly afterwards. They didn't want you to have to go through the 48-hour or whatever the requirement is in your bylaws for the meeting notice. But there's nothing really talking about an instance where it's not safe to have so many people close together at one time. So what we've been advising, and I've given an opinion to some of my clients regarding board meetings, is that I think that it's been okay to have a virtual board meeting where you post the notice in the same manner as you would for any other board meeting, but you say, due to the inability to have a meeting where we could have members attend with safe social distancing, this will be a completely virtual board meeting. Here is the telephone conference number, or here's the Zoom information, or whatever software that you use. Now, there's still potential for challenge for it, of course. There's nothing in the statute that allows you to specifically do that. But my reasoning has been, because the board has already been allowed to vote without being present in person, that you could vote over the telephone. I look at what the entity is that's able to vote, and in this instance, a virtual board meeting, the members are able to participate by way of commenting, but they're not really voting on anything, as opposed to a membership meeting where that's the members' meeting, that's their ability to cast a vote on something. And that's where I've given the opinion, especially, that you still have to have a physical location for them to be able to, at a minimum, show up, drop off their ballot, and if they're insistent on staying there, I wouldn't prevent them from coming in as best as they know. You would try to talk them out of it. You hope people would have common sense. But I have been advising our clients that there is no way, in my opinion, I should say this. I have not been recommending having a completely virtual membership meeting, because of the argument that somebody could say, I meant to cast my ballot and I expected to be able to walk up to our clubhouse the day of, and I wasn't able to do that. So now my vote wasn't counted. I'm going to challenge the election results. That's the fear that I have with it. So what a lot of communities are doing are saying, okay, we're going to have the physical location, but please, owners, if we ask you to either mail in your ballot or conduct your vote by electronic voting if you've established that. But if you need to show up, please just show up. You're able to drop it off, and then we'd ask that you go back home and you participate via the conference call, whatever, the Zoom or whatever it is. But please, we ask you not to stay, because we're just going to have a limited number of people there to be able to conduct the meeting in terms of calling the meeting to order, counting the ballots, and certifying the results and so on.
Right. So you have the physical location there to basically satisfy a technicality, but you're encouraging people not to actually show up there unless they really have to and can't opt into the voting procedures and so forth. One thing I wanted to mention in the electronic voting that we keep talking about, it requires the board to adopt a pretty specific resolution. So you're going to need to coordinate with legal counsel to prepare that resolution and make sure the notice goes out of the board meeting properly. There has to be an affidavit of notice too, confirming that the notice, the 14-day notice before your board meeting to adopt the electronic voting procedures was given. And in addition, people have to expressly, your membership has to consent in writing to participate using the electronic voting process. So the couple conditions to use it, you do need a little bit of lead time.
Yeah. In talking about board meetings, and I know we'll have a couple of questions, but I wanted to address John, who we work with, had mentioned, can we have a board meeting where essentially it's going to be at our clubhouse, we're able to use it, we want to have the board there, we'll all sit 6 feet apart, but we can really only fit another 12 homeowners there for them to be able to participate. And my response was, I think that's appropriate. I think you need to provide that in the notice that says space is extremely limited for residents, and we would ask that you call in, and we may not be able to accommodate you in terms of practicing safe social distancing if you choose to show up, because if you have space for 12 residents, but you have 20 people show up, it might be a first come, first serve type thing. So I think to answer John's question, for anybody else that has that question, I think that's perfectly appropriate. And that's probably the best result that I think that you can have. It's better than having a completely virtual board meeting, for example.
Yeah. I mean, there's still a level of risk associated with that. But look, ultimately, if it's a board meeting issue and a board decision issue, if someone challenges it, we might have the opportunity to do some ratification after the fact to kind of kill any claims,
Yep.
you know? So that's why we're not quite as concerned with board actions as we are with membership meetings.
The last thing we had on statutory changes is what about the flexibility with use of reserves for other than their intended purpose? We've had that question come up a little bit. You know, the only thing though is that you have the ability in the emergency powers to pass a special assessment, regardless of whether or not it requires membership approval, that the board can do that. But I would say that that needs to be in response to the emergency under which you're given your emergency powers. And I don't know that maybe you can take that position to say we're going to pass a special assessment because we're still in a state of emergency and a lot of people have stopped paying their dues in response, you know, to COVID-19. That may be the basis for it. But if you're already having difficulties and this was, I wouldn't use it as your basis to say, well, hey, we've got this window to pass a special assessment for this capital improvement project that we otherwise would require membership approval for. I wouldn't use it for that. But we have had some questions of, well, what, can we use the reserves for other than their intended purpose? And our answer is, I would advise against it. You have to have the membership vote. There's nothing in the emergency powers that allows you to use the reserves. Maybe that comes out of it later, although honestly, I would think that would be more in place in response to a property damage event because you're probably going to have a lot of unintended expenses to fix something than really in the result of a pandemic where the main financial impact is probably people stop paying their dues.
Yeah, but potentially we can see a statutory change, you know, allowing, you know, more flexibility with the use of reserves. I think it would be a good thing to consider.
The other thing, I don't have it up here, but I think that associations should take a look at their governing documents and their insurance policies in place. We're talking a lot about right now with potential liability, decision-making of the board, and the liability of the association. What if somebody gets sick? What if somebody contracts this and there's a claim that's brought against us later? For all of you board members that are on here, I'm sure none of you are getting paid to do this right now. And so, first of all, thank you for attending this and listening to some attorneys talk and giving up your time. But that goes with your service on the board overall. You put countless hours in representing your community. What you need to do is take a look at your documents and see, do I have protection in my bylaws? And Jim, what did you say one time? You said if you were ever to serve on an HOA board?
Yeah, I would have the most aggressive indemnification and advancement of costs provision in my governing documents possible.
Yeah.
Backed by the beefiest and most expensive insurance policy I could find, right? And unfortunately, you know, what we're seeing is very limited indemnification provisions in governing documents, not protecting the volunteers that are serving, right? So yeah. I have this rule that Ed's going to know, you know, he's going to know it right away. I have a rule against incurring uncompensated risk, but that's what you do to some degree as a board member. So at least what you want to do is mitigate that risk as much as possible. How? By looking at your documents and in your insurance policy.
Look at your insurance policy, talk with your insurance agent that you work with. I know that they've been fielding a lot of calls. We may have some on our webinar right now. Talk to them and see, hey, now that we're getting through this, how are we protected? What are you finding that maybe nobody realized before? There's a lot of things that we've all seen that you never really contemplated because we haven't had a pandemic for a long time. I mean, in terms of, I know there's been some very isolated scares, but nothing to the level that what we've had right now. And so everybody's learning something. And rely upon the people that you work with. Talk with your insurance agent and say, hey, how are we doing is there anything that you've seen for other communities or anything that's come up that we need to do from our D&O liability standpoint? What about our liability policy? Are there exclusions as to pandemics? You know, take a look at that and see what's it going to take to, when it comes time for renewal, to update our policies, and rely on the people that you work with on any other circumstance to give you the best advice possible that you can rely upon to make a good decision. But especially something that you can do as a board, probably 90% of you on here probably have bylaws that can be amended by board vote, is to take a look at that and make sure that you're properly protected. And a lot of them have, pretty good provisions. It's not something that we look at a lot as attorneys because I think it's something that board members maybe don't have to take a look at, and you typically have the D&O policy in place, but especially something like this where you're making these decisions. I don't have a manager that might be on the call right now that said, hey, Ed, this is the most trying time that I've had as a manager because you're being pulled in both directions. You've got people that are rightfully concerned for their health, safety, and welfare, and they're concerned about people being out there in groups of people, and why are all these people out here? And then you've got other people that are saying, hey, I bought in here, I pay assessments that go towards these amenities, and you're not allowing me to use them. What are you doing, manager, to do this? And so for our managers on here, I commiserate with you and understand that the best thing you do is continue to work with your board members and board members that are on here. Understand the position that you both are in, work together to try to find the best way possible based on the best interest of your community, the way that your community is. Rely upon, if you need to talk to your attorney, we've been involved a lot with a lot of these questions, and I promise that's not a plug for further legal services. It's just something that's come up a lot where it requires some type of advice. And my partner, Mike, if those of you have worked with Mike McCabe, my partner, he says, when you're getting an opinion from an attorney, you're essentially buying insurance. And so think of it that way too, because we do have malpractice insurance. So from that standpoint, rely upon the professionals that you're working with. And so that's kind of ends my little diatribe there. But so I'm going to leave this screen up for a little bit, but we do have a lot of good questions that I want to get to. If you have any more, I don't want to go too long just so we can get through, and we're happy to answer anything afterwards if we work with your community. But I wanted to answer a question, a couple here that I still had on that were emailed to me in advance. One question related to clubhouse rentals. If you're concerned about if you are renting out the clubhouse, if you're deciding to open that up, if people are going to abide by the 25%, that could be an easy thing of if you're not there with as a board function and you're not overseeing it, I think it's still perfectly acceptable to continue to not allow rentals of the clubhouse.
Or if you do, condition them on contractual indemnification backed by beefy insurance.
Yeah.
So you're going to want to control the contracts if you decide to do that, because you're still exposed as the premises owner to potential liability.
Yeah. I think, and then part of that question, I think we answered it was, can we require one at a time gym use? I think, again, it depends on the size of your facilities, what type of policy you put in place. I think if there's a reasonable policy that it could, I see a defense for that. Just looking at practically enforcing it might be difficult too.
Yeah, it could be a policy. It could be defensible.
Yeah. Another one that was a good question was elevator use. There's two parts of this of, can we mark off, kind of like when you're going to Publix or anywhere other store where they're marking off tape on the ground saying, if you're waiting for the elevator, please stand here. I think that's certainly fine. I don't think that anybody's going to try to argue that a temporary piece of tape is considered to be a material alteration, for example, that might require a member vote. So I think that that's perfectly fine. The follow-up or part of that question was, can we ask that no more than 2 people or use the elevator at one time? I certainly think that you could put up a sign that says, first of all, while we have cleaning schedules, you're using the elevator at your own risk. Please be safe and abide by social distancing. I hope most people, if it were me, and if I saw 2 people in the elevator already, I'm going to say I'm going to catch it the next time.
Sure.
So, but can you place something there asking that be done? Certainly, I think that would be possible. All right, so that's what we had from some of the questions that were emailed to me. All right, let's go back up to the questions that were typed here. And some good questions here about annual meetings, and I'm sure we'll have a question on. Sherry asks, for annual meetings that couldn't move forward due to COVID, if the proxies are still valid and the second notice was sent, do we need to renotice the meeting in accordance with the bylaws if they require a 30-day notice? So if the second notice has been sent and you've canceled it after the second notice was provided, my recommendation, there's nothing guiding us on this in terms of what the specific notice requirement is. I probably want to give them at least 14 days notice. I don't think that you're otherwise required to abide by your document provision as to when the second notice had to be provided in terms of that type of 30-day advance. I certainly think that abiding by that would be the safest thing.
Yeah. So there are differences in approaches. In terms of the proxies being valid, I'll tell you what the statute technically says. The statute technically says that the proxy must contain the date, time, and location for the meeting for which the proxy is given and is only valid for that meeting and any adjournments occurring within 90 days of that. So one problem is your proxy, if you've already sent it out, the date, time, and location of the meeting on that instrument is not going to be accurate. That could potentially be used as a basis to challenge. So depending on, but what also could be the case is you might not really need the proxy depending on what you have going on at your annual meeting. You might not need to attain a quorum. You might not care if you don't get a quorum, especially in a condo. And frankly, you might not want a quorum. It might even be better for you, more efficient for you. So any of you that get stuck in the middle of your election procedures, that's kind of where we need to, especially if you're in an HOA, you're going to need to get some individualized advice. And because there's some risks and some options you can go along with. We're dealing with some unprecedented circumstances that, we've already researched that issue, and there aren't really any court opinions or arbitration decisions telling us what we can and can't do in this specific context.
And kind of to piggyback on that, I had a question about if it is a condo election, for example, and you have advanced ballots, how long are the ballots good for? Like, in kind of going on with Jim's point, where if all you're having is the election and the quorum doesn't really matter because as long as you have 20% of the ballots cast, are the ballots still valid? And I actually emailed somebody from the DBPR that I've been in contact with, and she just said there's nothing in the statute specifying how long a ballot is good for. Right. So from that standpoint, I think that if you have emergency powers and if it's upheld that you have the ability to cancel or postpone meetings, and then you decide to use that ballot and now have to go through the whole process again, I think that's probably going to be defensible. I have a hard time finding an arbitrator finding that you improperly held the election because you didn't start the whole process over again. Yeah. What would be more concerning, you could have somebody arguing, hey, you shouldn't have started the process over again because now it's opening the door for other candidates that didn't get their name in on time, and now you're opening it up, and you diluted the vote that maybe could have gone to me as a candidate. I don't know, that could be a potential challenge. So, how should an association deal with a staff member that tests COVID-19 positive? Does the building need to be shut down? That's a good question for an individual, probably not for as many communities in here that don't have a staff member. Certainly, I think you want to make sure that they abide by the self-quarantining. That goes into a little bit more of maybe employment issues from, do you keep them paid? Do you furlough them? That's a difficult question that probably would require further analysis for your community specifically. The question is, does the building need to be shut down? I don't know that I would say that it needs to be. There's nothing saying that it has to be. I think that if you were to undertake additional cleaning and maybe notification to the residents regarding it, maybe without naming the person, I think those would be proper steps. But whether or not you need to shut down the building, I don't know. It would have to depend on what functions you have going on in your building, what type of amenities you may have. If you have offices in there, that would just depend on the kind of the use of the building, I guess.
Yeah, and especially if it's like a one-stack condo where shutting down the building means people can't go home, that would definitely not be something to recommend.
Yeah. I think we answered this question, but just to make sure we get through them, what steps should be taken if a board wanted to open the pool? Should there be additional signs? And what we said was notification to the residents containing the sufficient disclaimer language, and then also placing signs at the pool regarding whatever rules that you might have in place if you are opening them with limited capacity, and to otherwise recommend that they abide by the CDC guidelines for social distancing and that sort of thing. That's typical what we've been recommending to our clients that we've been working with.
Consider additional cleaning measures, consider, rearranging the furniture or removing some of it to, sort of encourage social distancing.
So Andrea has a good question. She said, with cleaning and sanitizing supplies in such short supply, how is the association able to be in a position to properly sanitize the pool furniture and restrooms in accordance with CDC guidelines? I think that that's all more of a reason to let people know that you're using it at your own risk. I've had one community where they basically had adopted a rule that essentially said, you're asked to bring wipes with you. We're not going to be wiping down after everybody. If you do have them, please bring them with you. I know in that instance, we advised against stating that we will be providing hand sanitizer and so on, because what happens if you say that you're going to and then it runs out, and then somebody, you can see that there's all these little step-by-step things that could, give rise to potential claim. So I think that, again, do what you can in your best ability. We're just advising against advertising it to make it think that if I'm an owner, oh, it looks like they're really on top of this, I feel more free to be able to go out and use this stuff and maybe disregard the social distancing. I want to make it feel like, hey, while we have cleaning guidelines in place, please know that you have the obligation to exercise common sense, abide by social distancing, and we've adopted these rules regarding the maximum capacity or something like that. Yeah. Okay, I think that we answered the question regarding gyms and fitness centers here. Donna says that we have a pavilion with bathrooms that are not attended. What issues do we have? The owners can also rent the pavilion. Any issues? I think with bathrooms, again, if you decide to keep those open, I know that some communities have maybe said, we're going to open up these more open air amenities, but we're still going to keep the bathrooms closed down, for example. Now, the only thing that may come up from a health standpoint is, and I have to look at this depending on what type of community is, if you're required to have open bathrooms for certain facilities. Again, that depends on the nature of the community that you have. But if you are not otherwise required to have bathrooms open, you may choose to keep those closed because that's more of a basis for a much smaller space, handles that are being touched, faucets and so on that are being touched, where it's more likely that it could spread from there. So if you chose to keep those closed, if you're not otherwise required by law to do that, I certainly think that could be defensible. And even if you were otherwise required by law to have it open, there's some analysis that says, well, based on the advice of local health officials, can we still keep this closed or not?
Mm-hmm. Yeah, and it goes back to the level of risk tolerance. The more things you do to mitigate the potential for someone contracting the disease in your community, the more you're mitigating your risk. The fewer things you do, the more your risk could potentially increase.
So Michael has a question here. Can we have residents, our members, sign a release, hold harmless, and waiver of liability agreement in favor of the HOA? We've had that question before. You can attempt to have that, but if somebody doesn't sign it, I would not give the opinion to say, well, if they don't sign it, they're not allowed to use the pool. I don't think that would be upheld as a reasonable type of rule that would be upheld by a judge, for example. So while you could require it, if somebody were to say, I'm not going to sign that, I'm allowed to use my pool, and try to stop me, I don't know that I would try to stop them, to be honest with you.
No.
Yeah.
Again, especially if the nature of their rights to use those facilities are easements, property rights, and the covenants and restrictions, you have no ability to impose conditions on that, like in exchange for execution of an instrument like that. So I don't know that I would suggest trying that. I mean, you could try it, but I wouldn't insist or make it a mandatory thing.
And I did see a comment for another presentation that basically said if the only way that you're willing to open the pool is if owners sign some type of a release, it might be better just to keep the pool closed for a little bit.
Sure.
You know? I mean,
what's going to make people more angry, right?
Similar questions here. If we open the pool or other amenity, are we somehow responsible for their social distancing? I don't know, again, from a responsibility standpoint, it still comes down to the theory of liability that if you choose to open it, and what happens if people are disregarding the rule regarding social distancing and somebody contracts it that was there, can they say, well, yeah, I know I was there, but you should have done a better job of enforcing this? I mean, that's always going to be a potential for liability. I don't know, but I wouldn't state that you should go down and try to break up and physically try to remove people. It's just a matter of how best can you enforce. If you can identify them or have a process for saying, okay, anybody past this 25%, this is a violation of our rules, and it could be subject to a fine potentially, that might be the basis for curtailing it. But in terms of if you're going to adopt it, I think you're kind of understanding that there's a potential for liability when it's open anyways. So I wouldn't worry about feeling like you have to be down there policing it 24/7. Let's see. I think Carol, we had some questions about rentals. Carol, if you can shoot me an email back, or if you have time still to type them in, I'm happy to answer that while we go on here. If an owner gains access to the closed facilities, such as jumping the fence, would they be trespassing? It's a good question, whether or not law enforcement, because I've had that happen before where somebody's in the pool after hours and law enforcement will come and that person will say, I live here, I'm allowed to use the pool. Sometimes law enforcement will say it's a civil issue. Sometimes they will be pretty severe and maybe not. They might strongly tell them to go back to their unit. It honestly depends on which officer that you get that's going to come out.
It also depends on the nature of the property rights. If they have an easement to use the facilities and it's an unconditional easement, then arguably they're not trespassing. If that easement's subject to the association's ability or to regulate or close the facilities at a certain period of time, then arguably they are trespassing. And that's actually an important question, because the nature of the obligation a property owner owns to any person who might be on their property depends on the reason why they're there. Are they an invitee? Are they a business invitee? Or are they a trespasser? And obviously, people that are there trespassing, you don't have as much of a duty to as someone that you've invited onto your premises. Right. So there's a bit of a scale given the nature of the person on your property.
So this point is, it basically said that neighboring communities have opened their amenities, but they have staff to monitor the areas, and that they are enforcing limited capacity. On the current statute, are we required to maintain staff? That's not required for anywhere under the state statute or any type of local or state order right now. There's no requirement to have staff up here. That was required. I think it still is in effect in Broward County.
Yeah.
I think it was in place for Broward and Palm Beach, but then Palm Beach, I think, if that was stricken. But I know down south they had that, but there was nothing ever up here that required that.
Yeah, nothing in Northeast. If you're in Miami-Dade, Palm Beach, or Broward, ask us separately, and we'll want to check those local orders.
I do remember, and I did speak with, and Chris might be on here, in Alachua County, that they dropped, they opened up the pools on a Saturday by way of their order. And I think I remember as part of it that there was a requirement that it be staffed, or that if you're not staffing it, that you can remove the furniture in a way that it can't be easily moved back. I think that was Alachua County. So again, it's going to depend on the local order. Take a look from the Alachua County if anybody is in here from Gainesville on it. But up here in Northeast Florida, there's nothing otherwise requiring that you staff it at all. Question is, what is the response to a resident failing to pay its full assessment based on the closure of community amenities? That's a great question.
Foreclosure.
Jim says foreclosure. The response is that there's a case, it's not exactly on point like this, but where an owner felt like I'm going to stop paying my dues because you didn't maintain the roof and it caused damage to my unit, so I'm going to stop paying assessments because you didn't do a good job of using my money to maintain the roof. The court has said, no, that's not a valid reason to stop paying your assessments. That's a separate cause of action that you have for your damages, but you still have to pay your assessments. And so I think that same case could be held in this, applicable in this context from the standpoint of, if you feel like the association did something wrong, by all means, you can feel like if you want to go hire an attorney and sue us for whatever damages, but from the standpoint of not paying your assessments, that would not stop your ability to collect assessments from them.
Yeah, it's not like a landlord-tenant situation where if the landlord fails to make the dwelling habitable, you can withhold some rent. It is not like that.
Ted asks, how would you enforce Robert's rules while on a telephone conference call via the telephone, board, and/or annual? Robert's rules, it may be required per your documents. The main thing that I always say is whether or not you enforce Robert's rules to a T, it's having some type of a parliamentary procedure in place. And so it is a little bit more difficult. I think by a telephone, probably you'd have to say somebody's going to be talking, and then when you're done speaking, if there's a pause, you can say, hey, I'd like to have the floor. I know it becomes more difficult when you're on the telephone. If you're attending a board meeting by telephone versus in person where you can see people raising their hands and so on. So I do understand that it becomes more difficult.
Yeah, consider using Zoom. As a matter of fact, there are great features to enforce those rules if you use, this kind of software. They're not paying us to say this, but like you can mute people, which I think is a pretty good feature.
Let's see here. Okay, I think we just answered this question regarding requesting a partial assessment refund for not being able to use the amenities that were closed. Again, just talked about that. You're not required to do so.
Yeah.
Nor should you. I don't even say not only not required, but nor should you.
Right.
Arguably, if you have that money, if you had suspended or maybe ramped down maybe any of the maintenance for those areas because they weren't being used, that should result in some type of cost savings to the membership at some point. But no, bottom line is you don't refund that money to the members. Maybe it plays out that you have a surplus at the end of the year because some of your costs went down, but it's not due to a refund. We had a question just to again summarize suggestions for a 55+ community. I think the main thing for a 55+ community is that that 95% of your people that are there, and I say 95% because you may have some family members or guests.
Or at least 80. We know at least 80%.
Right, 80% must be, right, to make it a proper 55+ community. That's probably more of an even greater basis to have more restrictions regarding amenity use, regarding people coming in and out of the community. And so the main thing I said there was, I think there's even more of a discussion to be had about keeping things closed or to have more restrictions in place regarding use of amenities or people coming in and out of the community because of the people that are at risk in a 55 and older community versus another community that doesn't have that designation.
Yeah. From a legal standpoint, there's no difference. From a practical standpoint, your population might be of a higher risk category.
Kevin asks, is there any increased liability by asking residents to bring their own chairs to the pool and not provide pool furniture and take them away when they leave? I don't know from an increased liability if you ask people to come and bring those there. I don't know that I could see any increased liability from that. I suppose if they bring all of it there and now everybody's bringing their own furniture and now they're sitting closer than if you had removed all the furniture. I mean, I guess that's more, but that's people undertake their own risk by choosing to congregate with other people. If they choose to bring their furniture or have the stuff that's there and try to move it closer, again, it's difficult to enforce from an association standpoint and maybe subject to a fine if you have a rule in place regarding that.
Yeah, I don't see it moving the risk needle too much.
Yeah. Suzanne asks, can we limit the pool to only residents and not allow guests? That's a great question. I've been hesitant to recommend that because of the fact that it's kind of the documents almost always state that the owners and their guests have the ability and the property right to be able to use the common areas and the common elements. And the statute, while it does allow the ability to consider property off limits, if you decide to close down the amenities and you're using the emergency powers, it doesn't state though that you can differentiate between owners versus guests. So there just could be a potential for challenge from that if you chose to do so. I mean, that's the biggest thing that I can say.
Yeah, and there's some case law in the context of community associations, particularly regarding gym use, where an association tried to prevent a personal trainer from coming in the premises. And there was easement language in the governing documents that permitted owners, guests, and invitees. Court said, that's an invitee. You can't restrict that individual. So the association lost that case.
Let's see. Michael says, so some kind of monitoring service would be a good idea to enforce the 25%. I think that if you're intending to do that, and do I think it's a common expense that you can incur? I could see it. You'd have to take a look at the governing document language. We come up with this sometimes where it's, can we use our assessments for this purpose? I'd want to take a look at that, depending on what type of broad authority you might have to use assessments for what purposes. But certainly, if you do have the authority, I think that having a monitoring service, whether it's through management or some type of outside service, maybe your security company would increase their, their rover or something like that to double check on that. That might be a way to do it. Okay, Carol, I'm sorry. I remember, and I think Jim, we had prepared maybe an email back regarding when do you expect the out-of-state rental restrictions to be lifted? And I think right now it's
presently it's indefinite in accordance with the governor's order. So it's going to be whenever the governor wakes up one day and decides, hey, I'll allow vacation rentals today, or until someone constitutionally challenges that order and the court says, hey, governor, you can't do that anymore, or you never had the authority to do that. So long story short, we could only speculate as to when the governor might change his mind. But what we can tell you is that per the executive orders, that suspension of vacation rentals is indefinite right now.
Yeah. All right, so just the last couple questions. Chris asked, basically said that some rules have been passed by the board without the 14-day notice. Can we send out violations or fines for these violations? But the thing is that the 14-day notice applies for rules regarding parcel or unit use, and it doesn't necessarily apply unless the documents require it as to common area use. So there's nothing in the statute that requires 14-day notice for a rule regarding amenity use. Right. So unless Chris, and I know which association, and I'm not remembering that it's in their documents that requires 14-day notice for all rules, they should be okay from that standpoint. Tanya asked just specifically about this, where you can find this on our website. We will be having a link that will make it a little bit clearer, but if you go to our website, flcalegal.com, on the top right, you see a little YouTube button. If you click on that, it goes to our YouTube page, and that's where the video will be posted. If it's not posted by tomorrow, it should be posted by Monday. We just have to do a little bit of editing for it and uploading it and all that. But that'll be available, and you can subscribe to it so that I believe when you subscribe on YouTube, you might get an email whenever there's a new video. I think that's what the case is. So we'd encourage you. We'd love to have you guys subscribe to it so when we post items in the future. I think, Carol, we answered this one too about the 14-day quarantine requirement for rentals from New York.
Also indefinite.
Also don't know. Yeah.
It's indefinite.
Yeah. So basically the question is, if an amenity is open and you find that the social distancing is not being followed, can we close it for 2 weeks and then try again? This all comes again under the discretion of the board, under its ability to administer and operate the common areas. I think if there's a reasonable basis for it, I think if you decided to do that, do I think there's grounds for it? Absolutely. And again, is it subject to challenge? Yes, as well. But do I think there's a rational basis? It's kind of like, hey, you need to follow the rules or else type of thing. Like I think about it with my 3-year-old. It's kind of like sometimes you deal with members. It's like dealing with my 3-year-old at home, which is if you abuse this privilege, we're going to take this away from you. So I think it's the same thing for your residents. The last question that we have is, if members don't follow the rules that are placed, can we enforce a 30-day fob or access card shutoff? So that would be, I think what you're saying is, if you can suspend individuals' use rights, there is a process for suspending use rights for violation of your rules. So what I would want to make sure is that it's clearly stated, whatever the rule is, that they're violating that rule. If you do adopt new rules in response to COVID-19, I want to do that and have that done at a properly noticed board meeting. And then if you do witness them violating that rule, it does require the board to vote to suspend their access rights, and then you have to go in front of the committee this is a finding committee, it's an enforcement committee, where they have to approve or deny because what you're basically doing is suspending their rights to amenities. And there's a process for that if it's not monetary related, and you have to go through the same process as imposing a fine. So yes, could you do it, but it does require you to take some steps before you do that there. All right, so thank you, everyone. In terms of getting a copy of the PowerPoint, you have my email address here. Please email me. I'll be happy to send you a copy of it. Check back to our website and to our YouTube page if you want to take a look at the PowerPoint, the presentation, or if you have a board member that couldn't attend today. We thank you all for attending these. We had over 240 people register for this today. So obviously we appreciate the participation that you have, for those of you that are still on right now, and for sticking with us. And thank you for allowing us to be your attorneys. It's been our privilege, and we're here to help you. Please feel free to reach out to us if we can assist your community, and we'd be happy to do so. So thanks everyone, and everybody stay safe, and we'll see you again when we do our next webinar.